Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This is a very famous case. Of course, it's not decided. Why I am telling is an important case. Before looking into the video, please refer to my previous video number 2334. 2334. Now we'll come to the topic. Supreme Court refuses to give stay orders. Supreme Court refuses to give stay orders on the suspension orders given by High Court of Kerala in regard to the suspension of MP Mr. Faizal. MP Mr. Faizal, Muhammad Faizal. His name is Muhammad Faizal. He is MP from Lakshadweep. So, while discussing the video number 2334, please remember, I have clearly told you that in the first month, that is on 11/1/2023, on Bhogi Day I have made that video. On 11/1/2023, this man, MP Faizal Muhammad, who is a sitting MP from Lakshadweep constituency, who belongs to Nationalist Congress Party, he was convicted to undergo 10 years punishment in a case of 307 IPC. Of course, it was also occurred during the election against a Congress candidate, some other person. So, in 2009, the case was booked against him, and after 13 years, in 2023, almost 14 years, he was convicted for 10 years. But the things followed suit very quickly. He was immediately, because once the conviction is there for more than 2 years, means according to Representation of the People's Act, section 123 and section 8 also. So very clearly they stated that if a person is convicted for more than 2 years, he will be debarred from elections for the next 6 years. So immediately his name was debarred, and the government was swiftly ready to conduct the by-elections for the Lakshadweep MP post. But immediately this man approached the High Court of Kerala, which suspended the sentence given to Mr. Faizal Ahmad. There, the High Court, please remember, High Court has noted that it is nothing but a wasteful expenditure, because 2024, the regular elections are going to take place. After all, 1 year is there. After all, 1 year is there. So, if the by-election is notified, if the by-election is conducted, lot of money, or it is a burden on the state exchequer. So, therefore, they have suspended the sentence. So, agreed by this, the Election Commission of India, or the Government of India, they have filed a petition before the Honorable Supreme Court to suspend the suspension given by the Honorable High Court of Kerala, but Supreme Court refused to do the same, and of course they will conduct the so-called regular trial, and they will decide the matter. So this is a political issue. Right now, Justice K.M. Joseph and Madam B.V. Nagaratna, they refused to stay the High Court orders which gave stay on the so-called suspension of the MP Mr. Faizal, as elections are to be held in 2024, and it is a wasteful expenditure on the exchequer of the state. This is the opinion of the High Court of Kerala. Now, better to hear the arguments. The Additional Solicitor General, Mr. K. Nataraj, on behalf of State of Kerala, he said that High Court opined that it is additional burden on the state. But please remember, it is against the spirit of Section 8 of the Representation of People's Act, because according to, already I told you the section, according to Section 8, when once a person is disqualified from holding the position, definitely, so he has to be removed and some election has to be conducted. But Hesse acted as though the burden would fall on the state exchequer. Of course. Therefore, Additional Advocate General says, Solicitor General says, it is an exceptional case that merits the suspension of conviction. When a person is convicted, yes, he has to be convicted. The elections can go on. Let it be 1 year. What is there? There are certain people who worked as MLAs or MPs for a few months. Is it not? So this is the opinion of the Solicitor General. Now, Faizal's advocate, he said, High Court has reasonably, correctly considered the case very minutely, Your Honor, Willard, and decided that it is a fit case for suspension of sentence. So here he is at another point, that is injuries. There are no visible injuries. The injuries available, they are not sufficient to make out a case of section 307, attempt to commit murder. Immediately, Solicitor General says, for establishing a case of 307 IPC, injuries are necessary. Suppose if a man is about to hack you and incidentally you have made a defense mechanism, no injury. But if the injury would have been there, you would have done to death, is it not? Definitely the case of 307. Injuries, the part of injuries may not be there also. So that is what is stated by ASG. Injuries are not required in a 307 cases. So anyway, the Honorable Supreme Court of India, they refused to entertain and posted the matter to 28/3/2023. Actually, whenever such cases do come, whenever a person is MP is convicted, remember the famous case of Lily Thomas versus Union of India 2013. So this is very important, and the representation filed by A.K. Upadhyay. In the previous video also we discussed Ashwini Kumar Upadhyay. He stated that the MPs who are having the blemished character, they should be immediately sent home and elections to be conducted. And actually his prayer is that the cases against the so-called MLAs and MPs should be tried as expeditiously as possible, as per the judgment given by our former Chief Justice of India, Sri N.V. Ramana. So with this I am concluding. Thank you very much.